AI is riding high on the hype curve at the moment as a lot of people see numerous opportunities of how it can be leveraged to increase business performance. But a recent ruling by the US Copyright Office has highlighted that organisations really need to think about how they're going to incorporate AI into their business model. So in my talk today, I'm going to talk about the ruling by the Copyright Office. I'm going to talk about some potential implications for organisations and how they need to start thinking about AI to avoid falling into some of the pitfalls. My name is Chris Buxton and I help organisations make the most of their data and technology enabled opportunities. Now, I'm not a copyright lawyer, so I'm not going to argue the legal point here. So what I'm going to talk about today is some opinions and thoughts that I've had around the use of AI within organisations. So the decision by the US Copyright Office is related to a graphic novel and specifically the imagery contained within that novel. The novel is Zarya of the Dawn by the author Kristina Kashtanova. And it was originally granted full copyright over all content. However, subsequently it appears that the US Copyright Office became aware that the author had used the Midjourney AI engine to generate the imagery contained within the graphic novel. Now, because of that, it subsequently withdrawn the copyright on the imagery itself, although it did state that the narrative, the story, and the layout of the graphic novel itself was still subject to copyright. Now, this actually was aligned to a previous Supreme Court decision. So in the Supreme Court decision, the Supreme Court found that for a piece of work to be classed as original and be able to be subject to copyright, it had to fulfill two criteria. One, it had to be subject to independent creation. So the individual creating that material had to be operating independently to create that material. And the second component, it had to be sufficiently creative to be unique as a piece of work. Now, it wasn't clear what it defined as sufficiently creative. Now, in citing that decision, the US Copyright Office interpreted that and basically has stated through its guidance that only human created content can be subject to copyright. So the US Copyright Office became aware of the use of AI as part of this because the author had mentioned it on social media. A journalist had seen this and then approached the US Copyright Office to ask questions about the copyright status of AI generated material. Now, in this case, the author argued because they had used the story as part of the prompt to the Midjourney AI engine, they were exerting creative control over the generation of the imagery. However, the Copyright Office determined that because the author had no control over the imagery that was being created by the Midjourney AI engine, they were therefore not operating independently creative as part of that process. But I think one of the big implications that really comes out of this finding by the US Copyright Office is that the copyright authorities, trademark organisations and intellectual property ownership groups have no current mechanism to identify what is AI generated material and what isn't. In this case, it seems to have been mentioned on social media, and then a journalist prompted the Copyright Office to look at the status of that material. If it wasn't for that indication, the Copyright Office would appear to have no indication of what is AI generated and what isn't. And I think the same applies across a whole range of industries, whether it's software development or trademark or other material. There is no mechanism currently to determine whether a piece of material is AI generated or not, unless the author comes clean and states the fact that it is AI generated material. I think globally we're seeing a lot of countries all struggling with the same challenge related to AI, and I don't think anybody's got a good answer yet. The worst thing that could happen in this scenario is all of these regulatory bodies operate independently, and we find that different countries have different regulatory regimes of how they treat AI generated content. So the big challenge for organisations, when we think about that broader context and we think about all the different types of material that could be generated using AI, we start to think differently about that ruling by the US Copyright Office. Because there's a lot of organizations, whether that's a software development organization that makes its money through the licensing of software products, whether you're a consulting firm that license intellectual property, if you're using AI to generate that material, it will not be subject to copyright, and you will not have the ownership of the intellectual property contained in that material. Now that is a big shift for organizations, and that is a significant risk for organizations if they're not aware of it. Certainly in social media, we've seen no end of posts from people that are talking about how they're using AI to generate content and generate material. Now the big risk for organizations in that case is that if the organization isn't aware that AI is being used in this way, they run the risk of losing ownership of their intellectual property because they're not actually aware that their staff are using AI to generate the content. We know AI has been trained by analyzing trillions of data points harvested from across the internet. Now these data points that are being harvested will also contain third-party copyrighted material. And the problem for organizations is that they won't know what is copyrighted material and what isn't. So when they're using AI to generate content, there is a real risk that the material being generated is highly derivative of the original copyrighted material. Now the challenge this creates for organizations is that they're not going to be aware of that until a breach notice lands on their desk from the original copyright owner that they've breached their original copyright. And that is a significant risk for organizations that is quite hard to manage because they will have no visibility into the data that is being used to generate their content at all. And as the US Copyright Office stated in their determination around the graphic novel imagery, the author has no creative control over the output that is being generated by the AI. So there is a big risk for organizations. They're going to be unaware of breaches of copyright until legal action is taken against them. Now, one of the impacts that people talk about when authors are unable to copyright AI-generated material, that it potentially undermines innovation and potentially undermines the creative process. Now, I don't agree with that. I think it encourages and supports the creative process, because I think the big risk here is that if you are able to feed in prompts and then are able to copyright the material that is generated, there is nothing to stop an author basically feeding in a range of prompts over a period of months, copywriting a whole range of material that then nobody is able to use. And as we've seen with the internet domains, we see cyber squatting. We see people buying up domains at low price and then squatting, knowing that somebody with a more legitimate reason to own that domain is going to come back later and pay a more significant price for that internet domain. And the danger within AI world is that we're going to see a similar AI squatting technique. And it creates an environment where creators are no longer certain about whether the material that is being generated by AI is legitimately going to be able to be used. What this decision does do to support innovation and the creative process, though, is place AI in the hands of the creative person. It puts it in the hands of the individual. And now it means that if you've got a great idea, you can use AI to generate that content, generate that material, and you don't necessarily have to have the range of skills necessary that a larger organization would have to make use of your great idea. And I think that's a brilliant thing. I think that is going to encourage innovation and encourage creativity using open source principles and open source ideals, where the real value item is the great idea. I think one area of uncertainty that this ruling does create, though, is that uncertainty about ownership. So within the ruling from the US Copyright Office, although it removed the copyright on the individual imagery, it still issued a copyright registration for the layout of the book and the story itself. Now, if we apply that within the context of a piece of intellectual property or a piece of software, the same rule would probably apply, that a piece of code, as an example, that had been generated by AI could not be individually copyrighted. However, the way that all of that code is incorporated and brought together could. And I think that creates quite a grey area for organizations. because the legal ownership and the legal copyright status of that whole piece of software now becomes questionable. And as an example, if the real value add of that software application is incorporated with a particular algorithm that is AI generated, that then becomes questionable, because if you lose control of that algorithm, a competitor could potentially use your big value add item, incorporate it into their own software product, and you lose that competitive advantage that you've worked so hard to create. But ultimately, does this mean the end of the copyright system in general and the end of the intellectual property ownership? I think reality, no. I think what it needs to do, though, is evolve to be able to cater for AI generated content. I think at the moment it's a binary conversation that it is either AI generated or it is not. I think in the future what we're actually going to start to see is how much of a creative process did the creator have to go through to generate the prompt necessary to produce the piece of work. And it's going to be the assessment of the prompt process that will guide whether it can be copyrighted or not. So in the case of the graphic novel imagery, the fact that it used copyrighted story generated by the original creator as part of the prompt to generate the imagery, I would argue actually there was sufficient independent creativity gone into the creation of that prompt. What is not clear, though, is what would be the circumstance if somebody else took the same narrative from a copyrighted material, fed that into an AI engine, and used that to create the imagery again. And I think that's another one of those significant grey areas when it comes to the use of AI. If you take original copyrighted material and use that to engineer a prompt, to derive something similar, even a very simple one of feeding in a blog article or a piece of intellectual property with a prompt that tells you to rewrite that in a different style, does the work retain the original copyright, or is it a new derivative piece of work that is no longer subject to copyright? That is a big grey area that I don't think anybody has answered yet. And I think because of all of these grey areas, what we're actually going to see is all of this is going to play out through the courts in the coming years as people find different use cases and different ways that AI could be leveraged to generate unique content that potentially is no longer subject to copyright, but becomes part of their intellectual property portfolio. And I think until we've got those legal precedents, this is not going to be settled in any way. My name is Chris Buxton, and I help organisations make the most of their data and technology-enabled opportunities.